Master Robertson is speaking today on the issue of remote cross-examination and a Master's Chambers update. Thank you very much.
Thank you. This has been put together in very short order. I was drafted only a matter of days ago by Donna Purcell. We had done some questioning seminars in the fall, and we were talking about something else, I think, and I told her my experiences, and suddenly I'm on the panel. Before I talk about questioning, by the way, I'm going to reverse the sequence here a little bit on the agenda. First of all, yes, the court is using WebEx. I learned how to use WebEx last week, and it took me 5-10 minutes to get pretty good at it. My biggest problem is fighting with my computer because the on-off switch is right where I would touch it to move it, to adjust how it's focused. That was my biggest challenge, which had nothing to do with WebEx. I learned how to use Zoom. What was it, yesterday, the day before yesterday, when we had a meeting with this panel as we were trying to plan this. That took me maybe 5 minutes. So one or the other, it doesn't really matter which you're using. It's the host that matters. The host, as I understand it, has to have the system, and then you were just asked to join. And you will figure that part out very, very quickly. Also, in terms of an update, we have been doing urgent and emergency applications by telephone. And in fact, I did one yesterday. We have been doing telephone applications, of course, for years. That's how in Calgary we've always done the Drumheller applications, because there's never more than 2 cases on the list there, and it's an hour-and-a-half drive each way, so we just do it by telephone. We have also appeared in Medicine Hat, Lethbridge, Red Deer of Calgary by telephone when the list is quite short. And actually, that works better than you might think it does. It works best with simple cases, but we have done it with not-so-simple cases as well. But we're moving to WebEx. The masters, we're going to be sitting masters next week. Master Prose and Master Mason will be sitting next week. I don't know how that's going to work. I haven't asked specifically because after today I'm done as a full-time master. It's not going to be me. But that is coming. It has been frustrating for us, as I'm sure it has been frustrating for you, because we would have liked to be working more and getting work done. I know there's a huge backlog, and I am being replaced by a part-time master, so there will be less person power to do the work with a huge backlog. I think it's going to be a real problem. The reason that I got drafted on this, I asked Pastor Prose what I should tell you about how things are going to work going forward. And he said, and this is a quote, "Your guess is as good as mine." There is a pandemic committee in the court that's been working very hard to try to get things organized, but we don't have any answers for you yet. We're just hoping to get things going very quickly. The reason that I got drafted for this is because when I was talking to Donna, I told her that I'd actually done video conference cross-examinations about 20 years ago. We didn't have the fancy Zoom or WebEx and the technology that's available now, but we did have video conferencing. And I remember there was 1 or 2 files where I had to cross-examine witnesses in I think Texas, California, and it just didn't make sense to fly them in, and they didn't want to come in, and the cost of getting them here was significant. So I had a cooperative other counsel, and we set up a video conference, and it worked very well. In another case, I called a witness at trial, at a civil trial, by video conference. The trial was, I think, scheduled for about 3 days. I had a witness from Phoenix who had maybe 15 minutes of critical evidence to give. And the other lawyer opposed video conference evidence, but I was fairly confident that the judge would allow it. So I asked at the outset of trial, And Justice Erb very wisely, in my view, allowed the video conference testimony. Otherwise, it would have been a 3-day adventure for the witness to, because of the flights at the time, to come to Calgary, meet with me, prepare for the thing, come to court, testify, and then fly back the next day at huge expense to everyone. He gave us 15 minutes of testimony. He was cross-examined. It was brilliant. Because of that, Donna thought I'd be helpful to talk to you. My point is that video conference questioning is not new. As I said, I did it 20 years ago. I also did it once, by the way, with Skype, where I had the witness live in the room, but my client was in Asia. And what I did was I hooked up the Skype connection, and then when I was examining the witness, this is discovery, I pointed the laptop at the witness so that my client could see what was going on, and then during breaks, I'd spin the laptop around so that he and I could talk, and I could get some instructions. Of course, it was middle of the night, I think, for him, but that was his problem. Anyway, that worked very well. And over the past 7 years, several times, I've been encouraging people in court to try video conference questioning because it works better than you think it would. We had a case with a fellow from Mexico who refused to come to Canada because he was fairly confident he was going to get arrested because the lawsuit arose from his fraud on some people. So I directed questioning by video conference. There are some complications, but it works very well. I also wanted to talk to you about the court system. You're probably not aware of this, but the court recording system is very advanced, and there are several microphones in the courtroom, and there are several channels. What that means is if you have a hearing live in court, the court reporter who's later asked to do a transcript has access to this recording, because we haven't had court reporters in the courtroom for years and years and years, at least not in chambers and not in most trials. They do it by remote. They're doing it from home using a video or rather an audio recording. But it has multi-channels, and you can separate the channels. You can raise the volume on one, raise and lower it on the other. What that means is that when people are talking over each other, or they're just hard to understand, the court reporter has the option to slow down the recording, and she has the option to isolate the channel so that she can figure out what somebody said. When we do telephone applications, we still have a good sound record, except for me. I'm the one on the telephone in the courtroom. It sounds like the Wizard of Oz, the voice coming over the sound system or the speakerphone. But at least the court reporter doing a transcript of that still has transcripts, or not transcripts, channels, separate channels. So she has good quality recordings. Once you're doing a court application with WebEx, if you want a transcript, I think the court reporter is going to get a monaural transcript or recording. Not only is it monaural, but when you are talking, as I'm doing now, your I'll get to this list, by the way, in a minute. Your own speaker cuts out, so you can't hear anyone else. So when you start interrupting and talking over somebody else, you don't realize that they're still talking. And all the result is it's just a complete jumble for anybody to try to make a record of. It's a jumble with reduced sound quality, all in mono, with two people or more talking, not realizing that somebody else is talking. So with all of this in mind, I have some rules about virtual chambers appearances, and this is the list that you've been given. If you're going to rely on case law or copies of rules or statutes, please send copies to the court in advance or have them available so that we don't have this sudden reference to things. It's those of you who have appeared in front of me know it's a constant irritant to me that at 11:15 lawyers get up to the podium and then they're handing case law to the other lawyer. So no one is listening to the person who's talking about the cases at all. We are all looking at the case law that he or she has just handed out. I like people to know what they're looking at and know what they're saying, and I like to listen to what talking about, so I have always asked for people to hand things out in advance. It gets even more problematic if you've decided to file an affidavit at the last minute. Everyone's trying to read it on the screen, assuming you can separate the screen and you have the separate monitor, as Michael was talking about. So if you have the idea that you're going to bring an affidavit in at the last minute, talk to the other lawyer about it, just adjourning the application so you can sort that out. Many of the things I'm telling you, by the way, resulted from a court meeting we had last week on WebEx. We had about 67 judges and masters all on WebEx at the same time, and we were all still learning. So we had dogs barking in the background. We had people who didn't realize that they could mute their microphone. We had feedback. We had pretty much every problem that you could anticipate. So my next rule is turn off your phone or put it on do not disturb. And if it's still going to vibrate, don't put it on the desk in front of you, because it sounds like a freight train, or it might sound like a freight train to everybody else. But of course, you won't know that because your speaker cuts out when you're making noise. If you're doing a court application, we have the same problem, only exaggerated with WebEx that we do in a normal court. You have to identify yourself. When you identify yourself in court, good morning, my name is Smith, first initial A, I'm representing a plaintiff. You're talking to me, you're talking to the clerk, and you're talking to the court reporter. The court reporter is getting able to identify your sound, and using the court system, may be able to identify which track you're on. With the WebEx system, it's really important that you do that, because the court reporter is going to end up with an audio recording that's of reduced quality with no tracks. And it's also important that every time you speak, certainly if there are more than only a couple of people on the call, that you identify yourself again, so you identify yourself repeatedly. If you have 4 or 5 people in a court application, and I've heard court applications where I've had 8 or 10 lawyers in the room, it's really important that you identify yourself. And for the reasons that I talked about overspeak, when someone else is speaking, don't make any sound at all. Mute your microphone, as we all have here when we're not speaking. The rustling, I have a habit of drumming on the desk in front of me. It's a terrible habit. But the rustling of papers, as I say, the dogs barking in the background, you're probably in your home. Your spouse might pop in to see how things are going. Your kids are wandering in. You're like Jimmy Fallon on the Tonight Show. Mute your microphone. But also, even if your microphone isn't muted, don't interrupt somebody else who's speaking. That's good practice in court anyway, but there are times when the other lawyer is saying something that is simply not at all borne out by the evidence. He or she's got something completely backward. It's appropriate to interrupt. As you've heard with Zoom, you can press your space bar and go live from a muted microphone. And here's a couple of little hints. Make sure there's some lighting on your face. This is something I learned last week. If you're going to set up your laptop in front of a window, you're going to be in silhouette. No one will be able to see you. And the other is to aim the thing at your face. We had judges last week where we were looking at, the bottom half or the top half of their face, because they didn't realize where the camera was on the speaker, and I guess never looked at themselves. When I have 2 or 3 lawyers in front of me, I like to be able to glance over at them from time to time to see how they're reacting to something. It's a very human system. I like to know what's going on. And one last rule is speak at a measured pace. This is do what I say, not what I used to do. You've heard that I was a theater technician. I was actually involved as an actor in university doing a lot of things. And I can recite Elizabethan English in iambic pentameter faster than anybody else. I used to speak very, very quickly. I had spent my whole adult life trying to slow down. So this is do what I say, not what I used to do. It's even worse with WebEx or Zoom. The sound quality is a little reduced. But if what you're saying isn't very important, talk as fast as you want, and I'll just wait till you're done. All of this as advice for court appearances. This is primarily for questioning. Now, I have modified them a little bit for questioning. Can you scroll up the thing so I can just read this? You've heard Michael talk. By the way, Michael, I was very pleased to hear that you've been doing questioning for the last 3 years or so by video conference, because obviously you aren't afraid, and you found out that it actually sometimes even works better. But you need to make arrangements to have all the documents available. When I started practicing, not back in 1981, it was very common to go to trial without doing an affidavit on production, as it was called then. Documents were often produced at the questioning. It was a very sloppy time. Now that we have affidavits on records required in advance, it becomes extremely important to do that and to follow up on that to make sure that everybody has the documents in advance, the records in advance, so that they're available prior to the questioning. Having 2 monitors, I think, is a great idea. I don't know how to do that, but I understand it's not very hard. What I used to do back 20 years ago when I was doing the cross-examinations is I put together a booklet of the documents. Often it's just mostly the affidavit, but any other records that I wanted to cross-examine on, and I made sure that the witness had it. Back then, I would have the lawyer sitting, the other opposing counsel sitting beside me. I'd have the court reporter sitting beside me, and maybe my client, but the only person by remote was the witness. But I made sure that any documents that I was going to examine on, he or she had in front of him. I heard Michael say that, it's a problem if you want to surprise the witness with something, but let's face it, you don't do that. I know Perry Mason used to do that stuff, but with affidavits of records, it doesn't come up very often. So it's not a real problem. Back in the day, I was worried about the oath because I'd have the witness in Texas, and the oath was being done by a court reporter authorized by the Court of Queen's Bench in Calgary, and was that binding? And, if you think about it a bit, first of all, you hardly ever have anyone charged with perjury, so it's not a real world problem for the most part. But besides that, you have a problem anyway. If the witness is in Texas, even if you flew them up and you gave false evidence under oath, they've flown back to Texas. I don't think the Crown's going to extradite them to bring them up on a perjury charge. So the oath, I think, works. I don't know of any case dealing with an oath taken by video conference, but I don't know why the courts wouldn't accept that as being perfectly valid. One of the attractions of doing questioning, for me, doing questioning by video conference, is it might get lawyers to get their head out of the records, because it becomes difficult to work with the records. I've heard what Michael said about how you can direct the witness to a specific thing. The fact is, if he has his copy of the contract in front of him and you have your copy in front of you, or whatever the document is, you ask him a question about something on page 3, he can respond saying, yeah, but on page 1, and he's able to control what he's looking at and draw you back to some other thing. That gets lost with video conference. But the bigger picture that I have is something that I learned late in my practice, which is don't look at the documents at all. Have them all there, and if you're doing questioning, ask about what happened, not about what the documents say. I have sat through far too many questionings where the other lawyer has gone through the documents in great detail, one at a time. Did you write this letter? Did you get this letter? Was it sent on this date? Well, of course, that's all admitted anyway by the delivery of the affidavit of records, unless it's been specifically denied. What I did was I would walk the witness all the way through the facts from beginning to end in chronological order, making it clear to the witness that the documents are there. You need to look at them to refresh your memory. I encourage you to do that. And then only once I'd gone through pretty much the whole story would we then go back and look at the documents one at a time. And I think this will be more pressure to do that more efficient way of questioning than to plod your way through the documents one at a time. It also forces everyone to be a little bit more efficient in both production and looking at production, I think. Some years ago, I was doing a wrongful dismissal case for a lawyer whose career had been blindsided by his employer, his in-house counsel, who'd fired him for trumped-up cause allegations. And the other lawyer, I'm quite sure, thought he was going to make the process very expensive and very hard for us by producing every single email that my client had written or received during the years that he was at the company. So we had thousands of documents produced. I didn't look at them. He sent them to me digitally. I just sent them to my client. My client was a lawyer. And I said, you look through them and tell me what I have to look at. And he did that and said, here's the 15 or so documents. And that's what I questioned on. And it was far faster than the older system of feeling that you have to look at everything in great detail before conducting questioning. There is also a couple of other slight advantages to questioning by video conference, one is you don't have any worry about the other lawyer giving signals to their client. Now, just before we get on the air here, so to speak, I raised the question of secret messages being sent using Zoom. If I were conducting a questioning, I'd insist that that be disabled completely before I got started, because I don't want there to be any communication between the lawyer and his client unless the lawyer wants to object. Occasionally, when I was doing questioning, or when I was sitting with my client who was being questioned, the client would look at me for some sort of visual cue as to how to answer the question, and I always just said, answer the question. Also, I think the effect of this is that you will be less afraid going forward of examining somebody at a distance. You can examine somebody in New Zealand with this, and the conduct money might be $50. I think that's a huge advantage. Anyway, the biggest problems at the end of the day using this system, in my experience, are both in court and and in questioning is crosstalk, as I said, people interrupting, and background noise. The dogs barking in the yard that you're not even aware of because it's just part of your environment, and it turns out it's driving everyone else crazy. So that's really all I have to say about all of that. Apparently, there are some questions.
Thank you, Master Robertson. So a few questions. The first one coming from Sonia. Do you happen to know whether Provincial Court and the Court of Appeal are using WebEx as well?
I have no idea. Sorry.
With respect to applications without notice, do you know if the Court of Queen's Bench has any plans to do those in the near future using WebEx?
I don't have any answer. I don't know why we wouldn't do that. We, the Masters, have proposed a couple of different protocols for moving forward. But as you know, even in what I might call the old system in Calgary and Edmonton, we did things differently. In Calgary, it's been a long tradition for the Masters to hear applications without notice on fairly straightforward matters in our private office without a record. And up in Edmonton, they don't do that. As I understand it, about a year or so ago, they started opening chambers at 9:30 to do ex-parte applications. Going forward, your guess is as good as mine, to quote Master Pros.
Thank you. A further question here is with respect to the restrictions in the pandemic, it's going to be difficult, I think, for some lawyers to take steps to significantly advance their actions. Do you know if any of the time that there has been in terms of the delay in moving files forward because of some of the issues we're having in getting into the courts are going to count towards that drop-dead rule 4.33?
Well, I was going to mention earlier, actually, and this is an answer to the question, that I fully expect that the Rules of Court Committee will be proposing a whole series of changes to the Rules of Court specifically to address the pandemic and the fact that we're going to have to be doing things by video conferencing, at least for the near future. And that might be one of them. I would not be at all surprised if Rule 4.33 had a specific exception built into it, the effect that this period doesn't count. But I've not been told that. That's my own speculation. In terms of the 4.31 and the delay and prejudice and so on, we have already accepted that there's something called institutional delay. An application is brought and it's not heard for 4 months. Well, you don't count that against the plaintiff trying to move it off. his case forward because that's the court requiring time to deal with things. I would expect that would be accepted for this circumstance as well.
Thank you. With respect to oral chambers, Joe Nagy had another question. He's saying that at least in Edmonton, the chambers judge does not have a copy of the court file, so he always brings an extra copy for the court. Is there any reason or expectation that that would change for a virtual application if those materials are brought to the court's attention in advance of the hearing?
That's interesting. That's another difference between Calgary and Edmonton Masters, by the way. We always get the files in advance, and I have always looked at every file before going into court, so I have some general understanding of what has happened to date, what the applications are that I'm going to hear. And then in court, I have the file in front of me, or at least I can have it pass it to me. In Edmonton, they don't do that. They wing it, and they rely completely on the lawyers. Going forward, until the Masters, at least, and the judges, by the way, in Calgary do not have files in front of them for morning chambers. Going forward, until the Masters are actually in the courtroom, or at least in the courthouse, the Masters won't have access to the files. So if there's something in particular you think the Master needs, you'll have to send it in advance or make sure somehow that it's before the Master. We, the Royal, we will be relying very heavily on lawyers sticking to what's actually in the affidavits and in the materials. Because in the past, I've occasionally, on my own, challenged lawyers on what was in the evidence. We won't have that opportunity.
Okay, thank you. David Barker has a question. With respect to objections during applications, it's his practice to stand up, get the presider's attention, and then sit down, wait to be called upon, then to present his objection, and then do that. How would you handle an objection during a video conference?
Well, of course, I am appointed ad hoc, by the way. There is a chance that I will be back occasionally, but not very much. What I would do, I'm suggesting, is that you at least put up your hand. If I've only got a couple of lawyers in front of me, I would expect everybody to be on the screen at once so I can see everybody. And put up your hand. If it is a particularly significant objection, as I say, the other lawyer is telling the Master something that's completely wrong. It's actually opposite to what's in the evidence, for example. I use the space bar and I'd interject and let me know, because I don't want my time wasted with a lawyer telling me a whole bunch of stuff that's wrong, only to have to change my thinking when it's corrected later on. That's a matter of subjective determination in a moment how far you go. Generally, we like for people to wait until the other lawyer is done and then straighten us out later on.
Thank you. I've got a question from Jean Oliver. Do you happen to know what the current process is for seeking approval of minors' settlements?
Masters don't have jurisdiction. I don't know why. Masters collectively used to think they have jurisdiction. It was actually Associate Chief Justice Nielsen, when he was a normal puny judge back about 5 years ago, had some research done and concluded that Masters don't have the jurisdiction to approve minor settlements. So people have occasionally brought them to me, and I just send them upstairs to the floor to speak to a judge. So because of that, I have no idea what else is involved now, because we don't do it.
Thank you. We don't have any further questions, but I just wanted to pass on a message from Russell Avery, who says, thank you for the memories and happy retirement.
Thanks, Russ. And thanks all of you. It's been an honor being a master and having you appear before me. I've enjoyed it immensely.